In a civil lawsuit involving a medical malpractice case, an accident case, or even a wrongful death case, does it matter who makes the opening bid in settlement negotiations? You want to know the answer? Come join me for a walk near the beach as I share with you the answer to that question. I am Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is, it might. But then again, it might not. So let me share with you what I mean. Okay, so let's say you brought a lawsuit against a careless doctor claiming that he was careless and caused you significant harm and injury. And now, during the course of your lawsuit, you believe that you are right. You believe that the doctor was careless. You believe that his carelessness caused you significant harm and injury. And you have medical experts, qualified, board-certified medical experts, who have confirmed that you do in fact have a valid case and that your injuries are significant and permanent. Now, the defense has told your attorney that, hey, they believe that they did absolutely nothing wrong. They believe that nothing that they did caused or contributed to your injuries. And they also believe that your injuries are not as significant as you claim them to be. And they also said, guess what? There is no way we're going to negotiate with you at all. We'll basically see you at trial a few years down the road. Well, now your case proceeds through the litigation. During the course of discovery, depositions are done, which is a question and answer session. And now your attorney learns information that he didn't really have at the time that the case was started or actually reviewed by the medical expert to confirm that you had a valid case. And by the way, this additional information helps you and your case. And it sheds light on the fact that the doctor who treated you, or one of the doctors who treated you, was careless. And that carelessness was a cause of your injury. And it departed from the standard of care. So now, who makes the opening bid? Who turns around and says, hey, listen, we think this is something that needs to be negotiated. We think this is a case that should be settled. Does that make a difference in the ultimate outcome? It can depend on when those settlement discussions start taking place. An opportunity might arise after I have questioned a doctor, and now it's clearly apparent to everybody in the room that this doctor was careless and caused you significant harm and injury. After that deposition is over, before the attorney leaves, after his client has left the room, now is a perfect opportunity to suggest to the defense, now might be a great time to start talking. And what does that mean? It means I am now presenting them with the opportunity and inviting them to start negotiating because of what just went on during the course of this question and answer session known as a deposition. I know what happened. The defense lawyer knows what happened. Everybody in that room knows exactly what happened and why they should be trying to settle this case. Now, remember something else. Just because one side might suggest that there's an opportunity to try and settle doesn't mean that the case is going to settle. It doesn't necessarily mean that an offer that might be forthcoming is going to be acceptable to me or my client. But it does present the opportunity to get them to start talking. Getting back to the question I raised at the very beginning, does it matter who makes the opening bid and starts to suggest settlement? In most instances, I think that answer would be no, because the defense could come to me at the very beginning of the case after I have started the lawsuit and say, hey, Gerry, listen, is there any chance we could try and settle this early, like now, very soon after this conference takes place? And the answer truly may be yes, it might be possible, but in all likelihood, that's not reality. And there are many reasons for that, but the biggest reason is that at the very beginning of the case, the defense has not done a full analysis of the case. They don't have all the records to fully evaluate the extent of your injuries, even if they were to assume for a moment that their clients, their doctors, their hospital staff was fully responsible for whatever occurred to you. So at the very beginning, it's very challenging for the defense to turn around, and even though they may want to try and start negotiating, it doesn't mean necessarily that this case is going to get actually settled. It doesn't necessarily mean that they're going to make a reasonable offer. So in what type of case would it benefit us if I were to be the one to go ahead and suggest settlement first? Well, it might benefit if they are on the fence. If they think that there is a possibility we might be willing to negotiate, and now this is very early in the case or midway through the case, they may turn around and say, you know what? We hadn't thought of it at this point because we're still evaluating the case and we don't really know the full extent of your client's injuries. However, this may be an opportunity for us, the defense, to get a discount to try and settle this case. Why? Because your goal, Mr. Plaintiff, Mr. Oginski, your goal as the attorney is to try and get as much money as possible for your client. Our goal right now is to try and minimize the amount that we are going to pay out to you if we feel it's warranted. So there may be an incentive that they had not really thought through at this point about trying to resolve this case, but it may present an opportunity for them to say, listen, we are willing to try and negotiate, but it would have to be at a very significant discount if we are going to go further with these settlement discussions. So there are many variables that go into answering that question, and that's why at the very beginning, I could not give you a definitive yes, and I could not give you a definitive no. So why do I share this question with you? Why do I share this information with you? I share it with you just to open your eyes, to help you understand how these types of cases work in the state of New York. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.